Managing HR for a smaller company often means you end up wearing many hats, have diverse responsibilities, and can find yourself in interesting situations. HR has almost become a catch-all for everything administrative in a business. So whether you have an HR person, an HR department, or you're an owner managing these tasks yourself, I'm going to help you understand the top 5 things you need to do to mitigate risk and keep your company compliant. The first and probably most important thing is your handbook. The best way to protect your company is to have a compliant handbook in place. You should review it on an annual basis to ensure you're up to date on all employment laws and regulations. Staying compliant is a must. And remember that when using the handbook and managing your employees, we're going to come back to this a few times, but you must be consistent in applying all of those policies. Not doing so can result in expensive litigation, especially with regard to employment discrimination. We recommend carrying EPLI, which is otherwise known as Employment Practices Liability Insurance, which can help cover the cost of litigation in the event you get sued. However, even though EPLI is great to have, litigation is time-consuming and will likely take you or your employees away from work, and there also can be deductibles associated, so it's not always less expensive. If possible, you want to avoid it. Number 2, and probably everyone's least favorite topic, is employee discipline. Anyone who manages people knows you'll end up dealing with your fair share of employee issues, so you have to be prepared to address and solve them in a timely and satisfactory manner. Ensure that all disciplinary actions are consistent, there's that word again, because letting the actions of one employee slip may end up resulting in a headache later down the road. When disciplining employees, remember, documentation is essential and consistency is key. All employees should have a personnel file, and all disciplinary documentation should be retained in accordance with state and federal record-keeping requirements. It's important to think about the way in which you move through a disciplinary process, and they will all be different. But having a progressive disciplinary policy is ideal. This might look something like, first, an employee will receive coaching or an initial discussion. Next, they'll receive a verbal warning, then a written warning, followed by a 3-day suspension without pay, and ultimately termination. You don't need to follow this path exactly, and you can always skip steps if the violation is severe enough. But this is a good roadmap for how you can go down this path. Number 3, we'll keep this somewhat short. Benefits. We're talking about payroll, we're talking about health benefits, and 401k management. These 3 areas often fall under the management of the HR umbrella. That doesn't mean you need to be an expert though. Each of these areas has many nuances to understand, so the most important tip about benefits is to be sure you are working with trusted professionals who handle these. And unless you have experience processing payroll, it is usually more cost-effective and time-efficient to outsource it, and you'll save yourself some potential tax liabilities. Just be sure you use a reputable and trustworthy vendor. Number 4, FMLA claims. If you're an eligible employer under the FMLA, you're required to offer up to 12 weeks of job-protected leave to eligible employees. Depending on the circumstance, you may be required to offer an additional leave or other accommodation under the ADA. So there are some definitions that we threw in there. But how do you know if you're an eligible employer is the first question you need to ask. FMLA is only applicable when you have 50 or more employees that are located at establishments within a 75-mile radius of each other. If you don't check that box, FMLA doesn't apply to you. So assuming you're an eligible employer, let's talk about what makes an eligible employee. An eligible employee is one who has been employed by your company for at least 12 months and who has worked at least 1,250 hours in that 12-month period preceding leave. Employers are obligated to provide the required documentation to employees who may need time away from work for an FMLA-related illness or condition and are required to track all FMLA usage. It's really important to note that your employee doesn't specifically need to ask for FMLA. If the employee gives you, the employer, any sort of notice, you're obligated to provide them with FMLA paperwork. This can be as simple as your employee saying they need some time off for medical purposes. And unless you have a policy for providing for paid leave, you are under no obligation to pay your employee while they are out. A lot of people wonder, what is a qualifying leave? What is that definition? The list is pretty straightforward. Incapacity due to pregnancy or childbirth, the placement of a child in foster care or adoption, needing to care for a child, parent, or spouse who has a serious health condition, the employee's own serious health condition, or a military-related medical leave. And number 5, unemployment claims. If you're in business long enough, you'll likely have to deal with an unemployment claim at some point. Sometimes they're justified and you'll cooperate accordingly, but sometimes you may have a reason to fight the claim. If that is the case, documentation is the key to success. All documentation should be submitted into evidence before the hearing, and all unemployment hearings are held telephonically. It's highly advised to have an attorney present on your behalf. You'll also need a witness present with firsthand knowledge of the circumstances surrounding the separation. You'll need to send copies of the evidence to the claimant, which is the person no longer working for you, and I recommend sending it at least 1 week before the hearing is scheduled. Hearing officers will ask for handbook acknowledgement pages, which is why your handbook is so important. Those policies must have been communicated to the employees if you hope to prevail on a claim where your employee was terminated due to violation of company policies. And one final parting tip, on average, HR departments spend between 10 and 20 hours per month Googling and researching issues that arise. Rather than rely on an attorney for questions about employee discipline, which can rack up billable hours, which can be very expensive, it isn't a bad idea to have an HR hotline that you can rely on. These services usually charge a flat fee and are a great resource.
For more tips to help your business grow, visit ffl.net/business-boost.